SJC-12653, Boston Police Department v. Massachusetts Civil Service Commission, and another.
Mr. Nooner, good morning.
Good morning. May it please the court, my name is Michael Nooner. I'm here on behalf of Michael Gannon. Michael Gannon was bypassed for appointment as an officer with the Boston Police Department due to a hair drug test.
I'm sorry, Counsel, voice up a little bit.
I apologize. Due to a hair drug test which tested positive for cocaine. Mr. Gannon appealed the bypass of the Civil Service Commission, which allowed his appeal, finding that the drug test was insufficiently credible to reasonably justify the bypass in light of the other evidence presented. Judge Elizabeth Fahey of the Superior Court overturned the Civil Service's decision, stating that it committed an error of law. Judge Fahey's decision is incorrect and must be reversed.
Okay, can you help me with this? I'm trying. My mind sort of spins when I try to figure out what the review is, the review process is. We're supposed to be reviewing Judge Fahey's decision only?
As far as
For an abuse of discretion or what?
As far as I know, the Judge Fahey's decision is under review and it's incorrect.
Okay, so we review.
The underlying Civil Service Commission.
As a matter of law, she abused it, or she abused the discretion?
It's an error of law.
That's an error of law.
Is the grounds that she found.
All right, so we're saying that she made an error of law that has to be reversed. But how would she be making an error of law if she were reviewing what the Civil Service Commission did? What we do, was it that we have to review whether she did it correctly?
Well, I mean, that's a great question. I don't think there was an error of law. I think the underlying Civil Service Commission decision got it correct. I think Judge Fahey essentially ignored the analysis contained in the Commission's decision. The Commission essentially found that the hair testing procedures cannot distinguish between cocaine ingestion and external contamination. The hair testing can determine that cocaine is present in the sample, but it can't determine how it got there. And what Judge Fahey essentially did was substitute her own decision for that of the Civil Service Commission. She essentially concluded that the hair drug test provided reliable evidence of cocaine ingestion, despite the Commission's conclusion to the contrary.
Supposed to defer to the Commission?
Yes. The Commission has deferred to the Commission as far as fact-finding. The Commission is the finder of fact, and it found that I mean, there's a world of scientific evidence presented to the Commission, and the science of it concluded that hair testing is unreliable.
Yeah, but the science is really much more complicated than that, isn't it? It does certain things well, and certain things are uncertain, right? I mean, I actually, because I couldn't follow any of this, I started reading through some of these studies. Why don't you break down what it is, what the facts are, and the way the Commission finds those facts? Because it doesn't generate false positives in the way we normally associate false positives, does it? Right? This test is reliable at identifying whether you've been exposed to cocaine, right?
This test, yes, it could determine whether or not there are drugs present in the hair, but what it can't.
But does that means ingested into the body, not
No,
just
no. There are two ways that drugs can get into the hair: through ingestion, or through external contamination or environmental contamination. And the science of it concludes that there's a lot of cocaine in the environment.
Yeah, but
on paper currency.
I want you to be precise, and if I'm misstating what the Civil Service Commission finds, because there are different steps in this. One is, we did tests. If you haven't been exposed to cocaine at all, we're not likely to get we're not going to get false positives, right? That's what the science says on that, right?
That's correct, but.
Okay, but let me go to the next step. The next step is, if we coat the hair with cocaine, like one of those studies does, then it's very difficult to wash it out, right?
That is correct.
And then, but
The
we
addition
don't,
of moisture to the hair can increase the amount of
then
drugs
we
present
don't,
in the hair.
but we don't seem to have any reliable science on what is the sort of ambient cocaine out in the environment, meaning how often it's on dollar bills or whether that can appear. That seems to be the thing that's most unclear in this science, right?
The studies have said that approximately 92% of U.S. paper currency
Yeah,
has.
but then I
has-
read the studies
And then
on
it can
that.
be transferred to the hair.
But it can't be, but then they don't find that it shows up in these tests. One of these studies actually did that, right? It doesn't end up in the hair. The only time it's ended up in the hair has been when you literally take cocaine, put it on someone's hands, and rub it into the hair, right? Those are the studies that show this.
I'm not aware of that. I mean, the science essentially shows that there's cocaine in the environment, and it can be transferred by dry transfer to the hair, and the addition of moisture can cause that
does-
to
and it
get
shows
into
up
the
in-
Can I ask you
follicle.
this, was this all worked out in the trial court?
It was, before the Civil Service Commission. There was ample scientific evidence presented on both sides, and the Civil Service Commission also took note of its previous decision in the Boston Police Officer Drug Test Appeals, specifically with the reliability of the hair drug testing itself.
Don't you have to couple it with the police department's policy of never allowing anyone to become a police officer who's had even one test?
That's correct.
So it's the
And
policy itself that has a problem.
I believe that it is. And
He had 4 of the tests that were negative.
The difference in the testing procedures between a new hire, there's one sample taken, one sample of hair taken, and for a tenured officer, there are 3 samples taken. So it's a less reliable test. And you get one positive test, and you can never become a Boston police officer. That's
But that's the policy problem.
that's a policy problem. I believe that it is.
Didn't the commission think so too?
I believe the commission said that in its
I thought it did too.
in its decision.
But okay, but if the test is, again, I was looking at the Jones decision. 98% of minority police officers and 99% of non-minority police officers, there were negative results, right? So the test is very good at identifying if you've had no exposure to cocaine, right? It's very good at that. What it's not good at is differentiating between types of exposure, right?
Yes, it can't properly distinguish.
Why isn't it a reasonable policy decision for the Boston Police to say, okay, you've had some exposure, and there's another part of that policy, right? Which is, explain why you have some exposure here, because there are innocent explanations for that, right?
There can be innocent explanations for that. In this particular case,
And that's not a reasonably justified hiring criteria, something that excludes out 99% or 98% of the people, and then asks if it triggers something, why you might have exposure to cocaine.
How would you know that?
I don't know. I mean, in this particular case, Mr. Gannon didn't know that. I mean, when he got the
Or he's
results.
not telling the truth.
When he got the results of the test, when he was phoned by the medical review officer, he stated that he was shell-shocked, and he immediately made a decision to, get retested. He contacted somebody at the South Boston District Court in the probation department and went down the next day and got a hair test done, performed by the same exact lab, the same exact procedures, and that test was negative.
Well, it was inconclusive, right? It was below the threshold number.
It was below the cutoff, and
But
the
it
cutoff, below the
showed-
cutoff means negative.
Well, it shows they don't have enough to make any kind of reliable conclusion, but there is some evidence of cocaine in his second sample, right? And his
Well,
hair has grown for 5 weeks.
I would disagree that they didn't make a viable conclusion because it's a negative. Anything below the cutoff level is negative because there isn't enough.
Right.
When was the second test actually done?
The second test was done the day after he was informed,
Of the
which was
hair.
approximately 25 days.
They immediately acquired the hair, his hair. The test, though, itself was not done right away.
The test was done, they took the sample of his hair the next day, though, April 21st.
All right,
The original test was done on March 27th of 2010.
yeah.
So it was about 25 days between the tests. And so, I mean, the fact that he acted so quickly just demonstrates, you know, it's sort of a consciousness of innocence. He wanted to get this cleared up. He was shell-shocked. He said, this can't be. I have to figure this out. What happened? He didn't have an explanation for it because he's never used cocaine in his life. And the commission found his testimony at the hearing to be credible, saying that he ardently, repeatedly, incredibly insists that he has never used cocaine.
Yep.
They found that testimony to be credible. And, you know, I would just say to you that there was some other evidence presented at the hearing. You know, we spoke about the retest that was done, but there was also other additional tests that he presented that were negative. He had previously been a Boston Police cadet, so at the request of the Boston Police Department, he tested negative in 2006, 2007, 2008. The retest that was done after at South Boston, that was 2010, and then there was another negative one in 2012, subsequent to the application process to become a Boston police officer. So there were 5 additional negative tests presented, and the evidence just, there was the only piece of evidence that the police department presented was this one negative test. I mean, one positive test, I
What's
apologize.
its policy?
And so their policy is that no matter what, one positive test, you can never become a Boston police officer. And the problem with that is the test isn't reliable enough to take such a sort of a draconian position on that. You know, other cases can, you know, you can reapply, you can, you take other evidence into consideration. This is one strike, you're out.
Well, I'd like to go back to Justice Link's first question then. I mean, we've got the commission, and they hear a lot of evidence. You mentioned some of it. But putting aside even the retests and the other negative tests from when he was a cadet, the commission credits him saying he never used cocaine. So what do we, and Judge Fahey takes a view looking at the policy. What precisely are we reviewing of Judge Fahey's decision? I'm still trying to figure out the answer to Justice Link's first question.
Well, Judge Fahey essentially concluded that the drug test did provide evidence, reliable evidence of cocaine ingestion. I mean, her footnote says, at least in this court's opinion, police department has reasonable justification for not hiring those who ingest illegal drugs. This statement presumes that the testing procedure demonstrated that Gannon ingested cocaine and that the testing did not do that.
So you're
It's
saying
not
it was
reliable enough.
So you're saying it was a abuse of discretion, an error of law for her to make her own determination as opposed to rather than review what was before the commission?
Yes, yes, I agree with that
That's the
totally.
answer.
All right.
Okay, then that's the answer.
Okay, well, Mr. Newman, we'll hear from Ms. Spector.
Okay, great. Thank you.
And I'm going to begin with you, Ms. Spector, on that very same question. Are we not, we're looking at the very same record that Judge Fahey is looking at. Are we simply doing a de novo evaluation of the civil service determination, or are we supposed to give any deference to the Superior Court's decision?
You're not supposed to give deference because the Superior Court, in my view, made 2 errors of law, and I did want to focus my time, my limited time, on the standard of review. So I appreciate the question. Judge Fahey was supposed to defer to the commission's fact-finding. That's what the role of the commission here was, to examine all of the evidence, which it did thoughtfully, to weigh the credibility of witnesses, to weigh the credibility of the scientific evidence, which was also submitted. And then the question on judicial review before the Superior Court was a very simple question that happens in all of the administrative procedure type cases that the courts handle under Chapter 30A, which is whether there was substantial evidence in the record to support the commission's decision. There clearly was. There was all of the evidence that Mr. Nooner outlined.
What are their fact findings on the science, as particularly as you can? Because they're basically adopting their view that it's not enough to get rid of an officer and we should apply. But what are their facts on the science? Because this seems to really boil down to whether the science is accurate and what their fact findings are on that.
Well, I want to respectfully disagree with the premise of your question, and I think it's a error that Justice Fahey made in ascribing to the commission in Mr. Gannon's case a decision to somehow import the just cause standard that applies to termination of officers. That's not what the commission did. It was quite emphatic, in fact, in numerous places we've pointed out in the brief, in pointing out that it was well aware of the lower standard, all that the police department...
I get that part. I understand the standard is reasonable justification, and I understand the difference between the two cases. What I don't get is, what are the Civil Service Commission's fact findings on the science, and whether those are whether there's substantial evidence to support that, given that this science is kind of developing and confusing?
It certainly is confusing, but the record before the commission, which is what's on review here, contained evidence that certainly would allow the commission to question the reliability of the test. A great example of that is Dr. Benjamin's testimony. He testified at Appendix Volume 5, page 18, and I'm quoting, "Hair testing has almost always been a question mark in the minds of a number of scientists." That same volume at page 43, referring to the 2006 Stout study. That was a new scientific study that was new to Mr. Gannon's case. In other words, it had not been before the commission in the earlier case. That study stated that removing cocaine from the outside of the hair and ensuring that hair has been contaminated, quote, is the weak link in hair testing, and that's the, quote, problem area. The Stout study also said, quote, there's no scientifically acceptable method that has been accepted for contaminated hair to test for cocaine. And Dr. Benjamin stated, and I quote, that has been my opinion all along as well. That was at page 45 of that same Appendix 5. In addition to that was the new article itself, which the commission quoted and relied on, which said, quote, regardless of a decontamination employed, the efficacy of decontamination washes is debatable. That's in Appendix Volume 3 at page 396. Those doubts, moreover, were only increased in Mr. Gannon's case because of the manner in which the test was administered to him. Because it was a bypass, he only went through one round of testing, whereas the officers in the BPD drug testing cases went through 2 rounds, the safety net or so-called follow-up safety net process. So based on all of that, plus in addition to that scientific evidence, there was the evidence of Mr. Gannon himself, who, to Justice Lowy and Justice Lank's point, the commission did look at credibility. They heard him. They found him to be very credible. In addition to his testimony, there was his earlier reaction of shock, the fact that he had 5 other negative tests. So the commission, which was the entity here charged with reviewing the facts, weighing the evidence, looking at the credibility of witnesses and so forth, the commission found, based on all of that evidence taken together, that the police department had not met its burden to establish by a preponderance of the evidence that it had a reasonable justification. And that.
Could you address, I understand that, that the commission was the fact finder and so on and so forth, but in the course of doing the fact finding, did they address Justice Kafka's question about the second test that he had done a day after, also showing some cocaine?
I think that's the way that the Boston Police Department sort of frames that test, but I agree with Mr. Nooner, that's not really there's a cutoff for a reason, and that test, his second test was below the cutoff. So
Do we know about the other tests that he took, like he had five other tests besides the one that was positive. What about the other negative tests? Were there any sort of cocaine in any of the other negative tests?
I think only more limited because the Boston Police Department, purportedly because of its record retention policy, was not able to provide full records. But there are results in the record, which I can, if you give me a moment, I can point to those. The negative earlier tests were at Appendix Volume 3. Page 687, 688, 650, 669, 651 to 652.
Okay.
Those were all the other 2006,
Okay.
2007, 2008, 2012.
I just wondered if there was a consistency in the.
Well, they were consistently all negative.
I know that, but I'm going to consistency in terms of having any cocaine at all present.
Well, I don't know, but the whole point of the cutoff is to establish a level above which some sort of inference arguably can be made, although that, of course, that whole inference is subject to debate given these serious questions about the reliability of the test itself.
If I can just step back to make sure that we understand what we are to be doing, or at least what you think we should be doing. My understanding is that we have the same record that the Superior Court judge had below, and we determine on this record whether there was substantial evidence to support the finding that there was no reasonable justification based on the test alone to find that Mr. Gannon had used cocaine once.
Yes, I think that's right. And I would just add that the commission also appropriately considered all of the evidence before it as well, which included Mr. Gannon's credible denial
So,
of.
but there is, you are not challenging the police department's determination that if they indeed had determined or had reason to determine that he had used cocaine even once, that that's a reasonable justification to not hire.
Well, had the evidence showed that he had ingested cocaine, I mean, certainly the commission does not challenge or take issue with the police department's, there is substantial deference to the police department's discretion as to what qualifications are important to be a police officer and actual use of an illegal substance. The commission does not take issue with that, although it did suggest that there might be some issue with staleness at some point. It didn't really conclusively answer that question because here it simply found that there was no reliable evidence of ingestion.
But you're not suggesting that we reach that issue?
I'm not.
That we determine whether or not the police department could use their no drug use period policy as whether that's reasonable justification to not hire somebody?
Whether that would be reasonable on a forever basis, I don't think that's
Not
I don't think that the court has to reach that, although certainly the commission's policy statement about that, I think, makes some sense, but I don't think that this court has to reach that issue.
So in terms of Judge Fahey's decision, if we evaluate whether we just look at the record and determine whether there's substantial evidence, and it doesn't much matter whether or not Judge Fahey so found. If we find that there was, then we find that she erred, and if we find that there was not, then we find that she was correct.
Yes, I agree.
So we're not
with that.
evaluating whether she made an error of law. We're simply evaluating it as if we are doing this de novo.
Yes, yes, that's correct. I guess when there is a second error, there is a second error that I think she made, which is on the issue of administrative notice, where I think she simply misread or misunderstood the commission's decision. But that's separate from the substantial
You're
evidence.
referring to her view that they relied on the earlier decision in their finding, and they said, no, we didn't.
More specifically, her reasoning that the commission had actually somehow imported the higher just cause standard, which it quite clearly did not.
I don't mean to cut you off. Are you, the Civil Service Commission's, does it make a finding about whether it is possible for someone to get this level of cocaine in their hair sample based on environmental? Do they address that in their findings, whether this is, because the study you just mentioned, for example, says basically the risk for environmental contamination alone to produce a positive drug hair test result is not clear. So that study says we don't know whether that's possible or not. Does the Civil Service Commission make any findings? I understand you could, if you're rubbing your hands in cocaine like one of those studies did, and rubbing your hands in your hair, you could generate that. But does the Civil Service Commission make a finding on sort of whether this type of environmental contamination is possible at this level?
I don't think that they made my recollection is that they did not make a specific
And if
finding.
they don't do that, meaning basically they may have created some kind of illusory problem, does that matter? Or I'm bothered by the fact that the Civil Service Commission is making findings about environmental contamination, which we have no idea is possible or not. And do we just defer to them if they don't know what they're talking about this?
Well, I don't think it's a question of they don't know what they're talking about. They, understandably had to rely on the expert
Right.
testimony and evidence that was presented to them, but it also.
Does the expert Benjamin say that you could get this off of dollar bills or something like that? I understand he says there's cocaine on dollar bills. When I read the studies again, it says this very, very tiny number. Is there any expert testimony that this is really possible?
I think
out
that
there?
Dr. Benjamin's testimony certainly is, I think does support the commission's, I don't know whether he used those exact words, I can't recall.
When I read Dr. Benjamin's testimony, I haven't read it yet, he suggests that environmental contamination, as opposed to these kinds of laboratory, self-induced contaminated hairs, is possible. He makes it, because I understand he's a credible person. He's Johns Hopkins scientist, he's a professor at a bunch of different places, but he makes that finding?
Well, I think my recollection of his testimony is not so much that he specifically makes that statement, but that he states maybe the converse, which is he raises serious doubts about the ability of the test to establish that a person, or in this case, he specifically says he believes that the test results do not establish that Mr. Gannon ingested cocaine. So he states it in that mode. Another piece of evidence that isn't really it's not scientific expert evidence, but it was a fact that the commission cited and that Dr. Benjamin testified to was the fact that the FBI had abandoned. That was a new fact, I think, since the earlier commission decision that the FBI had abandoned hair testing because of all of these concerns.
But again, I mean, I read the FBI letter. It says, it's much less conclusive. Identification of cocaine in an individual hair means that the individual was exposed to cocaine. That's the FBI says that. The next sentence is why they back out. What remains unclear is if that exposure was from an unknown contact. Contact is part of the individual's occupation, exposure through being in a room while cocaine was being used, or it is from personal use by the subject. The FBI backs off, not because it's a subtler back off by the FBI, isn't it?
Well, it may be so, but again, I think looking to the standard of review and coming back to that, it's really the commission's role here to weigh what, certainly the evidence is not 100% clear-cut, otherwise we wouldn't be here today, but it really was the commission's role to weigh all of this conflicting evidence, and it exercised its authority appropriately in finding some of the expert testimony on one side to be more credible than that on the other
So we're
side.
supposed to do a de novo review, yet defer to the commission?
Defer to the commission's fact-finding, yes. A de novo review of the Superior Court. Well, an examination of whether whether the commission correctly found that substantial evidence whether substantial evidence supports the commission's decision. But for example, even if this court or if the trial court might have weighed those studies differently, that's not an appropriate exercise of judicial review in this kind of a case.
So we stand in the same position as the Superior Court judge did, which is that we are reviewing it for substantial evidence.
Yes, that's correct.
All right, thank you.
Thank you.
Ms. Litzes?
Thank you. Good morning, Justices. I may begin, if I may begin, I wanted to follow up on a question Justice Kafker asked my sister counsel. There was no finding by the commission in this case specifically addressing the high level at which Mr. Gannon tested positive for cocaine. Mr. Gannon, it's undisputed, tested at a level of 12.2 nanograms over 10 milligrams, which is almost twice, in excess of twice the cutoff level, which establishes a positive. The cutoff level in this case is 5 nanograms over 10 milligrams. So what we have here...
That was the only time there was a positive, you mean?
Excuse me, Your Honor?
That was the only time, the one test that was positive, right?
Yes.
And do we know anything about the other 5 tests?
We know that the other 5 tests, Mr. Gannon tested negative.
But what does negative mean?
So negative means that that there was not enough drug in this hair sample to rise to the level of the 5 nanogram, 10 milligram level.
Do we know what level of cocaine was in them?
We don't know because of the time period in which those tests were conducted. We don't have the documentation. Okay. However, with respect to Mr. Gannon's South Boston test, which was taken 26 days after the...
I'm so confused about this. Why is I thought he asked for it right away. I thought he gave the hair right away.
So Mr. Gannon's hair test for the Boston Police Department test was on March 27, 2010. He was not made aware of the test or the positive test result until sometime thereafter in April, the latter end of April 2010.
Okay, and so it was as soon as he found that out.
So as soon as he found that out, he then went the next day to the South Boston court and submitted his hair sample to be tested.
And that explains the gap of 25 or 26 days.
That's correct, because there was a process in which the test was reviewed by psychomedics and then evaluated and then reported to Mr. Gannon. Okay. And in that South Boston test, what is I think critically important is that although that test registered as a negative, there was still a significant amount of cocaine present in that hair sample, but it was just barely below the cutoff level. Dr. Cairns testified in the commission hearing that the cutoff level that the hair sample would be tested positive was just Mr. Gannon's hair test sample was just a little bit below what we would call a positive. So it didn't establish that there was no cocaine on the hair sample. What it just established was that there was not enough to call it a positive. And this is critically important because I think it just reinforces the validity of the first test that Mr. Gannon tested positive for, which was 26 days prior. And so what
How do we get around the deference, or at least the substantial evidence problem, given the uncertainty in the science? I mean, I get that. I mean, that report that your sister just read that says we can't figure out how much cocaine is in the environment. I mean, and so we can't be 100% sure. And it seems like the Civil Service Commission is doing its own little scientific experiment. But at the same time, they're making findings and the science isn't clear. Aren't we kind of stuck with this?
No, Your Honor, and the reason why we're not, we don't need to defer, or this court does not need to defer to the commission's findings, is because when the commission commits an unreasonable interpretation of the evidentiary standard, such as the commission did in the Beverly versus Civil Service Commission case, no deference is due. The appeals court in Beverly recognized that what the commission had done in that case was require the municipality to prove the truth of the third-party allegations. And in Beverly, what we had was an employee or a candidate for a position with the town.
But I guess my problem comes down to the science here. If it's unclear, I get, this test is very good at saying whether you have exposure or not to cocaine, right? We all probably agree on that.
Yes, Your Honor.
It's not good at detecting when it's not clear how the science works when it's ingestion versus exposure. There's some testing out there that says you can get this stuck on the hair if you rub your hands in cocaine and then rub your hair. And there's also stuff saying there's cocaine on kids' desks and in dollar bills out there at low levels. But my reading of the science, and again, I know I'm not supposed to do this myself, and I don't want to, but suggests we don't know the answer of whether this kind of false positive is possible from environmental stuff. And therefore, the commission may not be out of line here. That's a long question, but did you get that?
I believe so, Your Honor. So I think I need to just step back a little bit,
Yeah,
if I
ahead,
can,
'cause I don't understand
to
how we do
answer
that.
your question. So the commission's decision can be reversed, not just for a failure to support its decision with substantial evidence, but also in its failure to apply the law correctly and the correct evidentiary standard. And what we have here is two distinct standards that are at play because the BPD appeals decision was imported by the commission in its analysis of the evidence, including the science. What it required the commission.
I find that less persuasive given that they do seem to understand the difference between reasonable justification and just cause. Whether they apply it, but they are aware of it. And they seem to be saying, because the science is so uncertain, it's not even good enough for reasonable justification.
So what they're saying is that the science, I don't think that the BPD appeals decision said that because it's the science is so uncertain, you can't rely on a hair test. I think what the commission said in the BPD appeals decision was that the test result, standing on its own, is not, it does not conclusively prove ingestion versus external contamination. And so in that respect, it does not satisfy the just cause standard. And what the BPD appeals decision said was.
But okay, so do that. So, because that's my understanding of this too. The test result does not conclusively prove. Can the commission then say that's not even a reasonable justification, in your words of your brother, of preventing someone from ever being a police officer when it doesn't conclusively prove?
And I think, Your Honor, I think that goes exactly to the heart of the issue, which is conclusive proof under the just cause standard and reasonable justification. In the Beverly decision, the employee that was accused of misconduct was in a prior employment situation was terminated because he was accused of improperly accessing the voicemail system for his former employer. And so the municipality, when it learned of this, it then conducted an investigation on its own in terms of determining whether the phone records from the former employer did show that there was evidence of him improperly accessing the voicemail system. And what the appeals court said in that case, I think, is particularly important. It said that the phone records did not conclusively prove the misconduct of the employee. And what the commission did by relying on that lack of conclusive proof, it misapplied the evidentiary standard that was applicable to a hiring decision versus a termination
But
decision.
isn't the stakes here are so much higher? Because if this science isn't reliable, a bunch of people, it's not going to be this one-time problem. We're going to be allowing the police department to rely on something that, especially because it's got sort of, when we look at dark hair versus light hair, it has different levels of accuracy. It just seems like this is a little different than that because it rises or falls on the legitimacy of the science, doesn't it?
I think that the stakes are, I would agree with you, the stakes are very high in this particular case, but also because the department has a goal and a mission to ensure that its officers and the employees that it hires are not impaired in any way by improper drug use.
But it has to have some degree of confidence in the test, doesn't it?
That's correct.
What degree of confidence can you have in a test that's inconclusive?
Well, Your Honor, I would disagree that it's, that the test is not
You think
inconclusive.
the testing is just fine?
I would submit that the evidence in this case and the evidence in the BPD's appeals decision said that the department can reasonably rely on this test, as it did in affirming 4 of the terminations under just cause standard in the BPD appeals decision. And what's notable about those affirmations of the terminations of those officers is they were all at a level that was in excess of the cutoff level at twice or triple times the cutoff level. For example,
But those tests, weren't they like multiple hair samples, multiple tests?
what they were is
More reliable testing?
I would disagree, Your Honor, that it was more reliable testing because.
More extensive testing?
Excuse me?
More extensive testing?
I would say that it involved multiple samples, and we don't have that here.
Yeah.
But what we do have in the BPD appeals decision case is we have 4 officers who tested at levels in excess of in excess of the 5.5 nanogram, 10 milligrams cutoff level. For example, Officer Bridgeforth tested at a level at 11.6. Officer Thompson tested at a level of 13.7. Officer Bridgman tested at a level at 10.1, and Officer Guidi testified at 10.6.
And what is your point? I'm sorry.
So the point is, in the BPD appeals decision case, what the court recognized when it was looking at those 4 officers, it said that the high level at which the officer tested eliminates or suggests that there is no risk of any type of false positive or that they were subjected to external contamination.
Does the science say that? Because I thought, again, we don't know how it works in the environment. So how is the science conclusive that high-level tests can only be from ingestion, or is the science undecided because we just don't know yet?
So I think that I think if you look at the Stout study, for example, and the DOJ study, what we had in that particular case, the Stout study, for example, tested the hair samples and subjected them to, they were rubbed with cocaine and then they were washed. Like what we have here in the psychomedics testing protocol, this is not a situation where it's just a hair test.
That's the other study. That's the Romano study, right? The Stout study actually isn't one of the ones they rub the cocaine into the hair, is it?
It is my understanding, Your
okay.
Honor, that it is. And so what they did is they contaminated the hair samples, and after they subjected the hair samples to the psychomedics wash protocol, which is what we have here, there was no evidence of any external contamination to rise to the level of a positive hair test. And that's why we have the cutoff level at the 5 nanogram, 10 milligram level, is so that it eliminates the risk of a false positive. Some testing laboratories may have a lower cutoff level, but in this case, psychomedics has a much higher cutoff level to eliminate the risk of external contamination.
Isn't Stout inconclusive, particularly when we're dealing with moisture on the hair, that you can have markedly increased concentrations of the drug in the hair if it's moist, right? So
But the psychomedics wash protocol was applied to those samples, and there was no false positives that resulted from that testing procedure.
I'm looking, of the 390 samples that were decontaminated, 379 samples had concentrations of COC above laboratory quantification limits. It just seems like they can't rule this stuff out yet.
Well,
And maybe I'm wrong, or even that the Civil Service Commission could reasonably come to that
Well,
conclusion.
that's what I wanted to ask about, because I want to get out of the weeds for a minute here. So I don't think the commission is necessarily saying that Judge Fahey applied the wrong standard when she was looking back at those hair testing appeals. What they're saying is that, okay, you take the number of negative tests, you take the police officer, the prospective police officer's testimony that we credit, and then we know about this other case. And we analyzed it, and we thought that the testing methodology was not sufficiently reliable enough for termination. Now, we're not applying that termination standard, we're just taking note that along with these other factors, we thought that wasn't good enough for termination, and that there's no confusion at the commission on what standard they're applying. What's your response to that?
I would disagree. I think that the commission did confuse the standards, and the fact that the commission didn't take the analysis forward when it analyzed the case under the BPD appeals decision and imported the just cause standard, the commission did not continue its analysis and address the fact that in the BPD appeals decision, what we had were 4 officers who tested at a level that was similar to Mr. Gannon's level. Mr. Gannon tested at 12.2 nanograms, which is similar, if not more, than the other 4 officers that were tested positive in the BPD appeals decision.
So another way for you to say it would be that Judge Fahey recognized that there was an error of law because the commission was applying the wrong standard and dealing with the methodology.
Absolutely, Your Honor, and I think Judge Fahey was absolutely correct in making that decision, because there was no analysis that continued under the reasonable justification analysis, distinguishing, for example, the BPD appeals decision and Mr. Gannon's case. And if I might add that, and beyond that, what we have here is a case that does not have any evidence of any bias, any improper motive, any political considerations, which are at the core of the commission's decision. And I think all parties agree here that nowhere in the department's decision-making and the commission's findings was there any evidence of that. And so it's incumbent upon the commission to defer to the department's discretion in making its hiring decisions where there's no evidence of bias or political considerations or favoritism, which go to the core of the commission's findings.
Would you argue that even if you thought the science were junk? I mean, I understand this is not a typical case where the Civil Service Commission gets to overrule the hiring authority, but if the science is totally unreliable, would you still say they couldn't reverse that?
If the science was totally unreliable, then it would be difficult for the department to have reasonable justification. But in this case, I would disagree, Your Honor, that there's any findings that the science is totally unreliable. Even in the BPD appeals decision, Commissioner Stein found that the test was reliable enough to provide some evidence of drug use, which was then, that particular finding was affirmed by the Thompson decision by the appeals court, that this does provide some evidence of drug use.
And what's the status of Jones, the federal case?
That is currently, it's gone twice up to the First Circuit. Then it was remanded on the second time. We conducted a...
Remanded on the fact, trying to decipher the science, or remanded for what purpose?
Remanded solely for the purpose of determining whether there was a lesser discriminatory alternative under Title VII. The department's evidence on summary judgment regarding the business necessity and essentially the reliability of the test was affirmed by the First Circuit in that decision. And in that decision, the court took particular note of your point, Justice Kafker, which was you need to look at the positives and the negatives in their totality. You cannot assess reliability of the test just solely on the positive results. Because in Jones and in here, for example, Mr. Gannon is not attacking his other negative hair tests. He is not attacking the accuracy. And so when you're assessing the reliability and the reasonable justification of this particular test, you need to take into consideration that those negative tests were found to be accurate.
Could I ask you to do something really pretty simple, which is to you tell us what reasonable justification really means? I'm so confused.
Reasonable justification means, Your Honor, according to the case law, that there are credible, inadequate reasons to support the department's or appointing authority's decision in making a decision not to hire an employee.
And the credible reasons are what?
The credible reasons here are the positive hair test by Mr. Gannon.
One positive hair test that the department believes is reliable.
That's right. And I would direct your attention, Your Honor, to the Cambridge versus Civil Service Commission decision by the appeals court. And in that case, the appeals court took particular notice of the fact that evidence of prior misconduct of a candidate for employment plays a role and supports reasonable justification for an appointing authority. And in that case, what the appeals court did is look at a prior incident involving the employee that was a domestic incident, a domestic dispute, and that was in excess of 10 years old. Here, we have a case where the drug test was only a few years old, and that supports reasonable justification, particularly when you consider that an officer cannot be impaired when conducting.
Well, I get that, but I'm just saying that, what does it take for it to be reasonable justification? Does it take confidence in a test that is in fact reliable?
I would say yes, Your Honor. I think that
Does the test in fact have to be reliable?
I would argue that there needs to be
Just believe to
reliability, but just like the court decided in Sherman versus the town of Randolph, the test does not have to be perfect. In Sherman versus the town of Randolph, we had interview procedures that this court found to be flawed, and even if those interview procedures were flawed, this court upheld the hiring decision by the municipality because there was reasonable justification to support the decision by the appointing authority. And there was no evidence, like we have here, of any improper motive, any evidence of bias or political considerations that played a role in the appointing authority's decision. So I would submit that that decision in particular plays a particular role here, because even if you determine that the test or find that the test is imperfect, the hair test provided a reasonable justification for the police department to determine Mr. Gannon was not an appropriate and suitable candidate for employment as a police officer. And discretion is particularly important here for the police department, because municipalities on one level receive deference under the standard for hiring decisions. But the case law also recognizes even greater deference where police appointments are made because of the public safety component. And so on those two particular points, they provide even more support for why Judge Fahey correctly made the decision in reversing the commission's decision. Because by importing the standard by the BPD appeals decision and subjecting the department's evidence to higher level of just cause, you remove the discretion that the department had in making a decision as to what an appropriate employee was, and did not give the department the freedom that it required in terms of making a hiring decision for a police officer.
Suppose they did use the reasonable justification standard as opposed to just cause, which you're insisting they did. But let's suppose that they actually did do reasonable justification. Is it on the basis of what the police department believed was reliable, or was it in fact reliable? Could the commission come back and say this was junk science, and yet the police department says, well, wait a second, I was reasonably justified in the hiring decision because I believed it to be good science?
I think that question goes to the heart of what is the department's and the commission's differing roles. Even if the commission disagreed with the department's interpretation of the science, if there were credible and reasonable reasons for the department to have made the decision that it did, then the commission needs to defer to the appointing authority's decision, or the police department's decision here. I think the case law is replete with examples of that where you have an appointing authority making a decision that the commission disagrees with. But the standard is one of great deference. And here, particularly where they exercise, where the police department exercised its judgment, relied on not just any particular test, but a hair test by one of the largest hair testing laboratories, or the largest hair testing laboratory in the world, one that has been licensed and accredited by numerous states as well as international organizations, recognized as a proficiency laboratory where test samples are spiked and they are blind sample tested to determine whether the quality control and the testing mechanisms are accurate. With respect to psychomedics, they have served as that type of proficiency lab. This is not like other hair testing laboratories that are the subject, I think, of some of the scientific
there's-
debate.
Is that what the FBI used? Is that the lab that the FBI had used?
I don't know the laboratory that the FBI uses
Used.
or used.
But there is no generally accepted certification standards in this industry, right?
It depends on what standard you're referring to. I think that the cutoff level, for example, is one that has been generally accepted, and the evidence in the commission hearing recognized is an accepted cutoff level to determine what is a positive versus what is a negative test.
But when you say they've been certified by a bunch of states, are there any standards out there for how to do that?
I think some states do have particular standards in order to obtain that certification. I think the record talks about, in this particular case, Florida, Oklahoma are some examples of states that have received, that license hair testing laboratories like Psychomedics, which is another factor that I think is particularly important here. Unlike the Sherman case where you had subjective subjective determinations made by employees within the municipality. What we have here is an objective test that is being used by a third-party accredited laboratory in assisting the department in making its decision as to whether the department should hire or screen out that candidate as an employee for police department position. And that only supports and enhances the reasonable justification that the department had in making its decision not to hire Mr. Gannon.
And is BPD still using hair testing as its criteria for hiring?
Yes, Your Honor.
So this will determine not only this case, but whether or not it may continue to use it. And does it use it even when there's no other evidence to indicate prior drug use?
Yes, Your Honor, it does.
So it is still the determinative test to determine whether a person can be hired.
That's correct, Your Honor.
Okay, thank you.
Thank you.